Now, this is another blow for the public protector, another court bid dismissed with cost.
Yes, that is right. That is quite correct. The application was dismissed because the court felt that there were no prospects of success. It's no different from the decision of the Supreme Court of Appeal a month ago.
Now, Sharita, for a public protector's report to be found unlawful, and this is not the first time, and unconstitutional, how does the public protector then expect that the public would trust her?
Okay, so that is a difficult one for me as a public interest lawyer to answer objectively. But I think that what is expected of the public protector is to engender trust in the citizenry of South Africa, and we hope that the public protector would pay heed to the judgment of the Pretoria High Court and other similar judgments in order to perform the functions as she is mandated to do in terms of the Constitution and the Public Protector Act. That is what we can hope for as a civil society organization, as a human rights center, and as ordinary citizens in South Africa.
Now, of course, the name public protector is very important. And I mean, for a public protector to have been found to misapply the law, and she's supposed to be protecting the public, but in most cases we find that it seems that she's supporting a certain faction of, the ANC or the ruling party. How important is it that she makes sure that she restores public confidence in this office?
It is of utmost importance that the public protector work in order to restore faith and trust in her office. The purpose of the public protector, the essence of the setting up of the office of the public protector is to do her utmost in every respect to protect the South Africa and the public against unlawful conduct of public officials. If the public protector fails in that duty, then she is failing in one of her core duties. And therefore, it is of the utmost importance, and I reiterate this, that she go back to what her mandate is, which is to actually protect the ordinary person and not to protect public officials against proper and correct investigation when they commit or allegedly commit acts that are unlawful or that may lead to use of funds in an inappropriate manner, which is precisely what happened in the Vrede Dairy project. The project was intended to benefit poor, vulnerable members of that community in what was meant to be a reform project to create employment and a source of income, in other words, to develop that community. But unfortunately, that did not happen. And the objective of the Public Protector Act is for the Public Protector then to investigate thoroughly and fully in order to determine why those vulnerable members who are meant to benefit in terms of that project actually were left alone and actually without any benefit or any gain, whilst a group of politically elite and well-placed public officials and private individuals benefited to the extent that they did, with no accountability at all. So that means that the public protector failed those intended beneficiaries, the very people that her office is set up in order to protect. And I think that is what the CASAC and the DA went to court for, in order to set aside that report and to declare it unlawful and unconstitutional.
I mean, I was going to ask you exactly that, Sharita, about the detrimental effects of not, following her mandate as the public protector and not a politics protector.
Yes, that is going into the realm of a different subject matter that I have no mandate to discuss at this point. But what I would like to keep it to is the fact that it would appear from the judgment of the court that the public protector in filing the report that she did, or in releasing the report that she did, it would appear that she sought to protect certain politicians. And in doing so, she failed to recognize that actually the duty of her office is not to protect public officials, but to actually investigate them as fully as she can in order to protect the rights of ordinary citizens. And that is where the difficulty arose with her report, is that it is incomplete. It failed to heed much of the information that was already in the public domain that was investigated by Amabongane, where several reports were released. The Treasury had already investigated it. Unfortunately, that Treasury report was not released as fully as it ought to have been. But that clearly set out the breaches of the procurement processes, the Treasury guidelines on who should be paid and how much and when they should be paid. So clearly the public protector didn't investigate as fully as she ought to have, and she also very significantly didn't release the report according to the lines that her predecessor, Advocate Mandelsela, had prepared. And she released something that was a departure from that report, and that was not acceptable, and really placed herself, eligible to be challenged on the contents of that report. Yes.
Right, Sharita Samuel, let me thank you very much for your time.